Threats to governor are not public record. State of Ohio ex rel Plunderbund Media, LLC v. Director, Ohio Department of Public Safety. Case number 2013-0596. Original action in mandamus. The Ohio Supreme Court on August 27, 2014, denied a request from a Central Ohio media outlet asking the court to order a state agency to release information about threats made against the governor.
We don't know. That's the problem. We don't know what they're doing at all here. A lot of stuff, for all we know, they could be including threats that don't involve threats of violence at all. We don't know what they're opening. We don't know what they're doing. They won't redact stuff. They won't give us anything.
Do you think that these are public records and therefore you're entitled to them?
Yes.
That's your argument?
Yes.
And if we determine they're not public records, then you're not entitled to them, correct?
Well, that's how it works, yes.
The contents of a security record, and those are exempt, correct?
They're exempt with regard to computers and infrastructure.
Well, they're exempt with respect to records that contain information directly used for protecting or maintaining the security of a public office against attack, interference, or sabotage.
Yes, it's the Infrastructure Security Act. They're talking about a physical location.
You think the word office means the building and the
Yes.
structure. You don't think it means the office held by an individual,
No.
such as the office of Chief Justice of the
No.
Ohio Supreme Court.
Protecting and maintaining the security of our public offices is essential to ensure that our government functions properly. The General Assembly recognized this by exempting security records from public disclosure. The fact that you haven't heard about it probably means the Highway Patrol is doing their job well, and it may also be that records like this aren't always to be disclosed publicly.
Well, it might also mean there isn't much of it going on.
Well, I don't know of public instances where an attack has gone beyond the threat stage, where it's gone to a substantial step or an attempt. That should not weigh against the protections of the statute. The statute is protective. It's preventative. It's to prevent these things from happening. And the fact that no one has made an attempt on the governor's life, which at least publicly, and I hope that's the case, or any public official, judge, director, is not a means to all of a sudden read this super strictly and to second-guess the very significant, compelling public interest.
Threats to the governor qualify under Ohio's public records law as security records, which are exempt from disclosure. The court ruled in a unanimous decision. Plunderbund Media had asked the Ohio Department of Public Safety in an August 2012 public records request for a number of investigations into threats made to Governor John Kasich conducted by the Ohio State Highway Patrol, and for copies of final investigation reports. The department denied the request, stating that the documents were not required to be disclosed because they are security records. Following a few months of ongoing communications, Plunderbund filed a request with the Ohio Supreme Court for a writ of mandamus to force the Public Safety Department to release the records. In the court's per curiam opinion, the court explained that security records are in part defined by the Public Records Act as any record that contains information directly used for protecting or maintaining the security of a public office against attack, interference, or sabotage.